In other news, in a stunning decision, Supreme Court justices ruled in favor of the governor's office, saying the legislature only needs a majority vote on a bill in order for it to pass. This means that the governor's TRAN bill for tax refunds did receive enough votes to pass, but whether or not action must be taken at this juncture is still up for discussion. It's a stunning upset for the Guam legislature, but a victory for Adelup. The Supreme Court of Guam ruled on the governor's request for declaratory judgment regarding the number of affirmative votes needed to pass a bill, agreeing that only a majority of senators present vote in the affirmative for a bill to pass. The case was brought forth after a dispute between the two branches of government on whether Bill 1-1S lawfully passed. The bill proposed to take out a $75 million line of credit for the purpose of paying tax refunds in full. At the time the bill was voted on in May, only 13 senators were present to vote. 7 voted in favor, while 6 voted against the legislation. Based on its interpretation of the legislature's standing rules, the bill failed because it did not receive the 8 conventional votes required to pass the legislation. But the governor's office quickly challenged that interpretation, pointing out that a majority of those present voted in favor of the measure. The governor cited a section of the Organic Act that reads, in part, quote, "No bill shall become a law unless it shall have been passed at a meeting at which quorum was present by the affirmative vote of a majority of the members present and voting," end quote. So he took the legislature to court. Supreme Court Chief Justice Catherine Merriman authored the opinion, noting that essentially the buck stops with the Organic Act of Guam because it acts as a territory's constitution. She disagreed with the legislature's argument that Congress's failure to abolish the legislature's standing rules on affirmative voting essentially signaled approval of the rule. While Justice Merriman acknowledged that Congress's authority would trump the question of organicity if it in fact approved the legislature's standing rule, she disagreed that Congress's inaction translated into approval, saying, quote, "Based upon the legislative history and amendments to both the legislature's standing rule and the Organic Act, Congress has not definitively resolved this question," end quote. The Supreme Court's ruling therefore determined that the legislature's standing rules on affirmative voting is inorganic. So what does this mean for the legislature? The governor's office, in a release, is already celebrating a victory and announcing the prompt release of tax refunds next year, even pointing to Legislative Secretary Senator Regine Biscoe-Lee to transmit the TRAN bill to the governor for his signature. But whether the legislature is required to act on the TRAN bill at all is not clear, at least not for the legislature, which recessed early from session to mull the ruling. While it's clear that the justices believe the legislature is wrong, they did not issue a judgment on what to do with the bill, which could potentially mean that the legislature won't have to transmit the measure after all. You can read the justice's opinion online at pacificnewscenter.com.